Hi guys. I've been thinking for a little while that maybe I should do a series on the laws surrounding service dogs. Um, I just thought maybe you guys would appreciate it. It's something you can listen to while doing handwork or whatever. And kind of give an insight how to interpret the laws. I'd like to get some case law going on here eventually, look at some case law. I don't know. I just thought it would be a fun and informational activity to do. So I thought we'd start with the ADA, if that's okay with everybody. Um, we'll go through the ADA and then we'll hit other stuff to get a clear understanding of the laws and the relations to each other and the different um, standards that each require, that kind of thing. So anyway, let's get going. So service dog handlers hear it all the time from people in the public. How do I make my dog a service dog? How do we go about doing that? Well, first we've got to cover the base requirement to even be covered by the ADA in the first place. You have to be disabled. So I thought I'd go through where the DOJ comments on the Amendments Act of 2008, and they describe what the definition of disability is. I thought I'd go and we'd go through that together. That's probably the easiest and the best thing to do. So let me get me out of the way. So we're going to look at the summary of key provisions of the Act and Rule. That's where it's going to tell us, what we need to know. The ADA Amendments Act made important changes to the meaning and interpretation of the term disability. Let me make sure I'm still, all right. I did this once before and the mic, for whatever reason, wasn't going. It was really upsetting. So the ADA Amendments Act made important changes to the meaning and interpretation of the term disability in the ADA in order to effectuate Congress's intent to restore the broad scope of the ADA by making it easier for an individual to establish that he or she has a disability. The department is making several major revisions to the meaning and interpretation of the term disability contained in the Title II and Title III ADA regulations in order to implement the ADA Amendments Act. These regulatory revisions are based on specific provisions in the ADA Amendments Act or on specific language in the legislative history. The revised language clarifies that the term disability shall be interpreted broadly and explains that the primary object of attention in cases brought under the ADA should be whether covered entities have complied with their obligations not to discriminate based on disability, and that the question of whether an individual's impairment is a disability under the ADA should not demand extensive analysis. The revised regulations expand the definition of major life activities by providing a non-exhaustive list of major life activities that specifically includes the operation of major bodily functions. The revision also adds rules of construction to be applied when determining whether an impairment substantially limits a major life activity. These rules of construction can also help an individual decide if they meet the standard of disability under the ADA. So they're useful to go over. These rules of construction state the following: that the term substantially limits shall be construed broadly in favor of expansive coverage to the maximum extent permitted by the terms of the ADA. That an impairment is a disability. Let me scroll up. That an impairment is a disability if it substantially limits the ability of an individual to perform a major life activity as compared to most people in the general population. That the primary issue in a case brought under the ADA should be whether an entity covered under the ADA has complied with its obligations and whether discrimination has occurred, not the extent to which the individual's impairment substantially limits a major life activity. Because we were getting into court cases and they were nitpicking the hell out of them. And they nitpicked somebody's disability to the point where they could just say they're not disabled, and they never got to whether the entity discriminated. That in making the individualized assessment required by the ADA, the term substantially limits shall be interpreted and applied to require a degree of functional limitation that is lower than the standard for substantially limits applied prior to the ADA Amendments Act, i.e. that was in the ADA prior to this amendment. That the comparison of an individual's performance of a major life activity to the performance of the same major life activity by most people in the general population usually will not require scientific, medical, or statistical evidence. And what they're saying there is if a normal, reasonable person looked at, the case, looked at the person's disability, they'd go, oh yeah, we can see it, they're impaired, to make it easier, in court cases. That the ameliorative effects of mitigating measures other than ordinary eyeglasses or contact lenses shall not be considered in assessing whether an individual has a disability. That an impairment that is episodic or in remission is a disability if it would substantially limit a major life activity when active. That an impairment that substantially limits one major life activity need not substantially limit other major life activities in order to be considered a substantially limiting impairment. The final rule also states that an individual meets the requirement of being regarded as having such an impairment if the individual establishes that he or she has been subjected to a prohibited action because of an actual or perceived physical or mental impairment, whether or not the impairment limits or is perceived to limit a major life activity. It also provides that individuals covered only under the regarded as prong are not entitled to reasonable modifications. Now, a service dog is considered a reasonable modification. So if you only meet the regarded as prong, that doesn't entitle you to use a service dog. The ADA Amendments Act revisions to the ADA apply to Title I employment, Title II state and local governments, and Title III public accommodations of the ADA. Accordingly, consistent with Executive Order 13563's instruction to agencies to coordinate rules across agencies and harmonize regulatory requirements, the department has adopted, where appropriate, regulatory language that is identical to the revisions to the Equal Employment Opportunities Commission, otherwise commonly known as the EEOC. Title I regulations implementing the ADA Amendments Act. This will promote consistency in the application of the ADA and avoid confusion among entities subject to both Titles I and II, as well as those subject to both Titles I and III. So, that was the comment part. Now, let's do away with the comments. Let's just see the text of the law. Nope, nope, nope. Nope. There we go. Right here. 42 U.S. Code 12102. Definition of disability. What is this? Go away. I don't want you. Disability. The term disability means with respect to an individual to summarize all of this. A physical or mental impairment that substantially limits one or more major life activities of such individual. A record of such an impairment or being regarded as having such an impairment. And we're going to look at the definition for major life activities. A, in general, for the purposes of paragraph 1, major life activities include, but are not limited to, caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, and we're not talking about people that are just klutzy, because I've heard the joke. Walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. So that it includes all those, but are not limited to all those. B, major bodily functions. For the purposes of paragraph 1, a major life activity also includes the operation of a major bodily function, including but not limited to functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. 3, regarded as having such an impairment. An individual meets the requirement of being regarded as having such an impairment if the individual establishes, that means you can establish, in some form of documentation. All of this is with documentation. You are expected to be able to prove this. If the individual establishes that he or she has been subjected to an action prohibited under this chapter because of an actual or perceived physical or mental impairment, whether or not the impairment limits or is perceived to limit a major life activity. My tongue gets all tied up sometimes, sorry. Paragraph 1C shall not apply to impairments that are transitory and minor. A transitory impairment is an impairment with an actual or expected duration of 6 months or less. Let's see how far up nope, good, go down. Rules of construction regarding the definition of disability. The definition of disability in paragraph 1 shall be construed in accordance with the following. A, the definition of disability in this chapter shall be construed in favor of broad coverage of individuals under this chapter to the maximum extent permitted by the terms of this chapter. B, the term substantially limits shall be interpreted consistently with the findings and purposes of the ADA Amendments Act of 2008. C, an impairment that substantially limits one major life activity need not limit other major life activities in order to be considered a disability. An impairment that is episodic or in remission is a disability if it would substantially limit a major life activity when active. E, the determination of whether an impairment substantially limits a major life activity shall be made without regard to the ameliorative effects of mitigating measures such as medication, medical supplies, equipment or appliances, low vision devices, which do not include ordinary eyeglasses or contact lenses, prosthetics, including limbs and devices, hearing aids, and cochlear implants or other implantable hearing devices, mobility devices, or oxygen therapy equipment and supplies. 2, use of assistive technology. 3, reasonable accommodations or auxiliary aids or services, or 4, learned behavioral or adaptive neurological modifications. Basically, what had gone on here is that people would go to court, claim a disability, but because they had devices, coping mechanisms, training, other things to help assist with their disability, then the courts were finding, well, you're not disabled. So then you're not protected by the ADA, but they were being discriminated against. So this went ahead and fixed that one. 3, the ameliorative effects of the mitigating measures of ordinary eyeglasses or contact lenses shall be considered in determining whether an impairment substantially limits a major life activity. As used in this subparagraph, the term ordinary eyeglasses or contact lenses means lenses that are intended to fully correct visual acuity or eliminate refractive error, and the term low vision devices means devices that magnify, enhance, or otherwise augment a visual image. So there you go. There is the actual text of the definition of disability. We have to be able to hit this before we even, this is the doorway to the ADA. This is the gate. We have to be able to pass through this gate before we even deal with the ADA. Anyway, keep watching for more videos. We go over more things. Bye.